and its contents is not an issue. Even if the purse was empty, you are permitted to draw an inference that there was a robbery. In other words, you must determine if something of value was taken or attempted to be taken in order for you to conclude beyond a reasonable doubt that there was a robbery. Anything further on that additional or supplemental instruction? Okay, and at this time, ladies and gentlemen, we'll take a short recess. Again, a reminder not to discuss the case among yourselves, and we'll resume in about 10 or 15 minutes.
Okay, so that's Judge Baxter giving her instructions this morning, ending up with an instruction having to do with count 2, the felony murder charge. And now they're taking a little break. Let's talk about that felony murder charge for a second with my guest, Bob ALTCHILER. You know, I find, as you and I were speaking during the instructions, I find this to be incredulous, this instruction. In fact, I'm going to issue a challenge to my friend Nancy Grayson when she comes back on this show. I want her to, on her show today, I want her to explain how there's any evidence of a felony murder instruction, because I know if there's anybody that can do it, Nancy Grayson will be able to do it. But let's go right back to Bob for a second. Here's my point. The whole theory of this case was that the rabbi paid Janoff to murder the rabbi's wife. Not to go over there and commit a robbery on the rabbi's wife, but to murder the rabbi's wife. Felony murder would be if he was involved in a case in which he said to Janoff, go over and rob my wife, and while that was happening, a struggle or something broke out, and Janoff murdered his wife. That would be felony murder. There's no evidence of that. Have I missed the point here? Don't say yes.
Well, it's a heck of a point you make. The fact of the matter is if before the grand jury, if there's evidence that supports some type of felony murder, then they can ask the grand jury to indict. Now, at this point, the standard generally is if any reasonable view of the evidence supports that charge, the jury can get it. Right. It's easier to get it to the jury if it's already in the indictment, which it is right now. Now, off camera, we talked about how it's possible, what possibly could support a felony murder charge, and the essential element of felony murder in this case, and for a jury to find felony murder, they would have to disregard what Len Janoff says, which is a problem for the government. Even if there's a felony murder conviction, it only can happen if the jury had chosen to disbelieve Len Janoff about an essential aspect of his testimony. Now, the jury...
And substitute their own views of what the testimony that was never given... Right. And say these are the real facts, although no one has ever testified to this.
Right. The jury, based on what they heard in this case, if they develop on their own a scenario in which they believe, let's say, the rabbi was feeding information to Len Janoff, giving him information about how much money his wife carried home. I warned her, so my house has $15,000, $25,000, planting the seeds for a robbery, hoping that Janoff would do that, and thinking that maybe a murder would take place during it, or not even thinking that a murder would take place. Maybe he hated his wife so much that he wanted her to be brutalized and robbed. You know, who knows? But your point is well taken, that it would involve and require incredible creativity by the jurors. It's a great appellate issue if the jury comes back, and if the jury comes back with a felony murder, disregarding the capital and disregarding the conspiracy.
Let's go step 2. Are jurors allowed to do that? I mean, as I understand the evidence in this case, there has been no evidence whatsoever to support that theory that you said would support a felony murder. That is, the evidence that has been adduced in this case is, and then argued by the prosecution and put forward by the prosecution, is Newlander was having an affair. Newlander wanted his wife dead. Newlander found Janoff. Newlander promised Janoff $30,000 if Janoff would go over there and kill his wife. Janoff and Daniels went over there 2 times, and on the second time, both with the intention of making it look like a phony robbery, but with the intention of killing her. In fact, on the second time, that's what happened. Janoff goes away. Janoff later confesses and implicates the rabbi. There has not been one piece of evidence that said, the rabbi said, go on over there and rob my wife, and maybe with a little bit of luck, the rabbi thinks, you know, if something horrible happened to my wife. There's not one piece of evidence. Are jurors allowed to just kind of say, well, you know, here's a better story?
Well, they're not, but for the viewing public, people watching this show right now, if there is a verdict of guilty on felony murder, you will hear the defense attorneys get up, and they probably couldn't put the argument better than the way that you just put it. because that's what's going to happen. And that is the remedy that a defendant has if a jury comes back with a verdict that is not supported by the evidence.
All right.
After the verdict comes in, defense attorneys will make motions to set aside the verdict.
All right, now what about a motion before this case gets to the jury and before these instructions are read, where the defense lawyer gets up and says, you know, Your Honor, I move to dismiss count 2 of the indictment. And the judge says, why? And you say, well, because of failure of proof, lack of evidence in this case. And then makes the argument that I just made. The judge reviews it and says to the prosecution, what do you got to say about that? And the prosecution says, well, Your Honor, you know, maybe, who knows, could be. And I recognize that it doesn't take much evidence to get to the jury. But this is one of those cases where I see no evidence supporting this particular theory. There's plenty of evidence to support a murder case. That there's no argument about. But the notion of a felony murder that took place because Janoff really went over there to rob her, not to murder her, I don't get it.
It is incredibly rare for a judge, either in federal court it's called Rule 29,
right,
or in the state court, the states have their various rules. It is very rare for a sitting trial judge to make a decision of that magnitude before a case gets to the jury, because most of the time the judge realizes that, let me get it to the jury. If the jury comes back, then maybe I'll take some kind of action.
Right.
The other issue is sometimes a defense attorney won't want to make that motion in advance because they want to give, this is an extra way for the jury to hang in this case. They have capital murder, they have felony murder, they have conspiracy. A jury can't simply hang only on the issue of whether there's guilt or whether there's not guilt. They can hang if there's a split between those that want the capital murder,
sure,
and the non-capital murder,
sure,
or the conspiracy and the murder and all that. So the defense strategy may be, keep the count in there.
Yeah.
We have the issue, you know, we have the issue for arguments later on or on appeal. Why limit ourselves at this point?
You know, it's interesting, though, and then we're going to go to a break about what you said about judges who say, let's get it to the jury and see what happens. We saw that happen recently in the King case in Florida, where those 2 boys got convicted, and the defense lawyer said, you know, let's not let this go to the jury, and the judge said, go ahead. Then they got convicted. He said, oh, my goodness, we better review this. And for some of you who may even remember the nanny case of several years ago, where they let it go to the jury and the judge came back and said, we got to change this. But, you know, courageous, perhaps, would have been the words of doing it before they let it go to the jury. All right, look, we got to take a break. We want to remind you about CourtTV.com's Unsolved Crime series, Hidden Traces. Now, this week, find out about the case of the missing heiress. A wealthy widow disappears in 1995. Is her body somewhere in the Mississippi River? Several psychics seem to think so. Log on to CourtTV.com for the story and an online chat with the reporter Harriet Ryan at 2 p.m. Eastern Time today. And we'll be right back.
Hi, I'm Andrea Thompson.